Ladies and gentlemen, I would like to extend a very warm welcome to all our participants, dignitaries, and our highly esteemed speakers to the Q&A session on the Companies Amendment Act 2020, Understanding Decriminalization of Offences, organized by the IMC Chamber of Commerce and Industry. All participants will be muted to avoid any disturbances during the course of the session. To consume less bandwidth and have clarity, you're requested to stop video streaming at your end. Kindly post all your relevant queries in the chat section so that the same can be addressed during the Q&A session. As we begin this session, may I request Mr. Rajiv Podar, President, IMC Chamber of Commerce and Industry, to present the welcome address. Over to you, Mr. Podar.
Thanks, Selby. Mr. MP Shah, Mr. Manoranjan Das, Mr. Shroff, Mr. Amit Desai, Ms. Radhika Parela, Mr. Saurabh Shah, ladies and gentlemen, a very good evening. It's my proud privilege to welcome you all to today's event on understanding decriminalization of offences under the Companies Act 2013, passed, planned and executed by IMC's Law Committee. To facilitate ease of doing business in India, the Ministry of Corporate Affairs has sought to decriminalize the Companies Act 2013 by introducing the Companies Amendment Act 2019 and Companies Amendment Bill 2020. While the COVID-19 inevitably has a wide range impact on companies in India, hopefully these timely amendments will foster faith, improve corporate governance, and facilitate investment. The objective of today's event is to appraise the participants about the effect and implications of the changes introduced by the amendment on administering of companies and compliance requirements. I'm extremely grateful to Mr. MP Shah, Regional Director West, Ministry of Corporate Affairs, for accepting our invitation to address us today. On behalf of the IMC Chamber of Commerce and Industry, I would also like to thank Mr. Bharat Rose for sponsoring our event today. I also express our gratitude to our today's panelist speakers of the day, Mr. Manoranjan Das, Registrar of Companies, Mumbai, Mr. Shroff, Chairman Shardul Amarchand Das, Mangal Das and Company, Mr. Amit Desai, Senior Advocate, for sparing the valuable time and being with us today. I also welcome Ms. Radhika Parela, Partner Shardul Amarchand Mangal Das and Company, and Chair Corporate Subcommittee IMC, and Mr. Saurabh Shah, IMC Managing Committee Member, for moderating today's session. Before I conclude, a few words about IMC. The IMC Chamber of Commerce and Industry is the apex chamber of commerce, trade and industry in the Western region, with its membership base of over 5,000 members and over 150 trade associations affiliated to it. Together, it represents and advocates interest of over 4 lakh businesses and industry establishments across the country from diverse sectors of the industry. Thank you very much. Selby, over to you.
Thank you, Mr. Podar. May I now request Mr. Saurabh Shah, member of the IMC Law Committee and the IMC Managing Committee, to present the introductory address. Over to you, Mr. Saurabh.
Thank you, Ms. Selby. It is indeed my pleasure and privilege to introduce our newly appointed Regional Director, Western Region, Ministry of Corporate Affairs, Mr. MP Shah. I would like to mention that Mr. Shah took over as a Regional Director a few days ago, but he arrived in Mumbai last evening, and today it is his first day physical in Regional Director's Office, Mumbai, and he has joined us. So, sir, a very big thank you to you on behalf of the Chamber and on my personal behalf, sir. Mr. Shah is a graduate in Commerce, a law graduate, and is also a member of the Institute of Chartered Accountants of India and also a member of the Institute of Company Secretaries of India. He was selected through UPSC and was appointed to the Indian Corporate Law Service of the Government of India, Ministry of Corporate Affairs. And since then, he has held several important positions, which inter alia includes Registrar of Companies, Uttar Pradesh and Uttarakhand, Registrar of Companies, come Official Liquidator, Jaipur, Rajasthan, Joint Director in the Office of Regional Director, Western Region, Mumbai, Northwest Region, Ahmedabad, and Northern Region, Delhi. He has also held a very significant position as a Regional Director of Northern Region, Delhi, Northwestern Region, Ahmedabad, and Southeast Region, Hyderabad. Sir, with this, I would welcome you and I would request you to share your thoughts, your wisdom on the subject. Over to you, sir.
Thank you, Rajiv ji. Respected Sri Rajiv ji, Sri Shardul Shroff, Sri Amit Desai ji, and my colleague Sri Amar Das, Registrar of Companies, Mumbai. As you know, this is my first meeting after taking over as the full-time regional director of the Western region. Since last 2.5 months, I was holding the additional charge of Southeast region and this Western region simultaneously. And now let me congratulate Mr. Rajiv Podar, President IMC Chamber of Commerce and Industry, and Saurabh Bhai for his team for conducting this meeting and inviting me today. As you all are aware that once the Companies Amendment Act 2020 is implemented, we will see a number of changes in the way the corporate functions in the country. If we go through the series of the amendments that have taken place after 2014, we'll acknowledge that we have reached from ease of doing business concept to the ease of living concept. The latest amendment includes reduction in amount of monetary penalty, omitting the punishment with imprisonment from the act. Penal provisions have been removed in many of the sections. Recategorization of the compoundable offences to an in-house adjudication mechanism. Adding the provisions relating to producer companies also. Since we have subject experts to deal with the amendment relating to the decriminalization of offences and reduction of penalty provided in the Amendment Act today, I do not wish to deal with them separately, but I would like to take you attention of the overall principle behind these amendments. Taking the example of the offences in our country under the Companies Act, when ROCs are filing the prosecutions across the country, many of the cases are related to non-filing of balance sheets and annual returns. Section 92 and Section 137. In 2019 Amendment Act, we have shifted the offence relating non-filing of balance sheet and annual return from fine or imprisonment to in-house adjudication. In further 2020 Amendment Act, we have substantially reduced the penalty amount under these sections. The maximum amount of penalty under 92 of the Act for a company for non-filing of annual return in time has been reduced from 5 lakh rupees to 2 lakh rupees. And the maximum amount of penalty under 137 of the Act for non-filing of balance sheet has been reduced from 25 lakhs to rupees 2 lakh. This is a economic capital. If we convert this into the percentage, then we can say we have reduced to 92. We have reduced by 92% of the penalty. Besides that, we are also going beyond this. If you read carefully the provisions of Section 92, Section 137 and Section 454, then it will reveal that no penalty will be levied by ROC for companies which are willing to comply. For the benefit of all, let me read the relevant provisions of Section 454, which is proposed to be amended. It says, in section 454 of the Principal Act, in subsection 3, the following provisos shall be inserted, namely, provided that in case the default relates to non-compliance of subsection 4 of section 92 or subsection 1 of subsection 2 of section 137, and such default has been rectified either prior to or within 30 days of the issue of the notice by the adjudication officer, no penalty shall be imposed in this regard, and all the proceedings in this section in respect of such default shall be deemed to be concluded. Meaning thereby, if ROC initiates any proceeding under for non-filing of balance sheet or annual return, he initiate adjudication, and if the company has already complied with or it complies within 30 days, then no action will be there. So this is a great relief as far as the business community is concerned. The idea is to facilitate greater ease of living to law-abiding corporate. That is why it can be said that the Company Act 2013 has traveled from ease of doing business to the ease of living also. Nice. Similarly, let me give one more example. There is a major change how this in the coming days this will be enforced. Section 16 example, it provides that it protects the existing company if any other company is incorporated with a similar name. So that company can apply for, or it's the owner of the trade name, then it can apply to the regional director for change of the name. And such applications are decided by regional director. And usually we used to issue directions to the respondent company to change the name if it is found to be proper. Then it is seen that the respondent company or we can say defaulter company or accused company is either not traceable or is not willing to comply with the directions of the RD. So in such case, we have to advise ROC to take prosecutions, which is again a lengthy process. So there is a major change. Now the amendment provides for allotment of a new name to the non-compliant company through artificial intelligence by the central government. Yeah, though we have yet to implement that, but in case the company is non-compliant of the directions of the RD. So this way, there is no need to file a prosecution and not going to court and declogging the trial courts. The law will take its own course. In this case, the law will take its own course without going to the court procedures, and RD's directions will be complied at RD's level. In short, there are many innovative ideas in the new Companies Act, which needs discussion and further dissemination of information to the entire corporate section, so that we will do business in a better environment. Presently, if a company is incorporated, the company can continue to do business. If the company does not want to do business, for example, for a temporary short period of time, then the company has an option to be declared as a dormant company under section 455. And if the company does not really want to carry on as a corporate entity, then it can strike off. So the Act has provided ease of doing business, ease of living in all respects. So in this way, we can see that the amended 2020 Act will definitely go a long way in reducing the burden of the courts and as well as the NCLT, because many of the provisions are now RD have been empowered, and monetary limit has been increased for compounding the offences. Let me once again congratulate the organizers for our conducting this meeting and for giving me the opportunity to interact with the vibrant entrepreneurs and professionals of this region with the IMC. Thank you.
Thank you, sir.
Thank you, Mr. Shah. As we move on to the panel discussion, may I request our moderators of the Q&A session, Mr. Saurabh Shah and Mrs. Radhika Dudat Pereira, member Law Committee, of which she represents as the chair of the corporate subcommittee, to kindly introduce us to the esteemed panelists and take us through the session. Over to you, Mr. Saurabh and Mrs. Pereira.
Thank you once again, Ms. Selby. And I would like to give a brief introduction of the Registrar of Companies, Mumbai, Mr. Manoranjan Das. Mr. Das is a member of the Institute of Company Secretaries of India. He has held several important positions in his career, which inter alia includes Assistant ROC and ROC in Punjab and Chandigarh, Assistant Official Liquidator and Official Liquidator at Chandigarh, Assistant Director and Deputy Director in Regional Director's Office, Calcutta, Deputy Director and Joint Director in Ministry of Corporate Affairs, Headquarters, New Delhi. Over to you, Radhika.
Good evening, everyone. It's my pleasure to introduce you to Mr. Shroff and to Senior Advocate Mr. Amit Desai. Mr. Shroff is the Executive Chairman of Shardul Amarchand Mangaldas. Over the years, he has spearheaded many landmarks, complex transactions. He's been appointed by the Government of India on many high-powered committees to make recommendations and advice on the drafting of new legislations and in respect to the amendments of existing laws. Including in recent times in regard to the drafting of the Insolvency and the Bankruptcy Code and the amendments to the Companies Act 2013, including in regard to the decriminalization. We welcome you, sir. We are also fortunate to have with us Senior Advocate Amit Desai. Mr. Desai is India's leading authority on criminal law. He not only represents Indian and global corporates, lenders, and celebrities in complex criminal cases, but he is also on several occasions been appointed by the government on several landmark cases as a special public prosecutor. Welcome, sir. With this warm welcome to the August panel, we'd like to now share with you a brief overview of the flow of event. We'll commence now with the Q&A session, followed by questions that will be addressed to the panel by industry experts, Mr. Suresh Kotak, Mr. Sailesh Haribhakti, and Mr. Narayan Shankar, who have graciously joined us today to address our August panel. With their queries, which will be no doubt very insightful to all of us. Thereafter, we'll take questions from the audience. We request our audience to please forward us the questions in the form of chats to enable us to make this session a very interactive session. So thank you very much. And now we will begin our session with a question by Mr. Saurabh Shah, my moderator, to Mr. Manoranjan Das.
Thank you, Radhika. Mr. Das, may I request you to respond on this particular statement that with decriminalization of offences, there is a view that the reduced quantum of penalties and their decriminalization will lead to increase in the quantity of defaults, subsequently reducing the quality of compliance and governance, corporate governance. Your views on this, sir?
Thank you, Mr. Shah. I don't think there will be the government. This is a continued effort of government policy of Government of India to decriminalize the non-compliances of minor technical and procedural nature offense and promote age of doing business in the country. And the government has been making continuous effort continuous effort in decriminalization of various offences, where it will be very cost effective for the corporates. The time taken for settlement of any offence will be reduced like anything through the in-house adjudication mechanism, and where the companies will come forward to make the make good the offences at a very short period of time with paying a limited amount of penalty and go ahead with their activities. I don't agree. uh, Hello.
Uh, Hello, uh,
Thank you.
Mr. Shroff. We'd like to like your views. How do you see the impact of decriminalization of the offences on proceedings that are there under the Insolvency and Bankruptcy Code? And what are the protective measures should the companies, its KMPs, and the directors take so that it doesn't trigger off other provisions which are there in the specialized legislations?
I think first and foremost, Radhika, it must be made clear that the two Amendments Act, namely Act 22 of 19, passed and with effective from 31st July of last year, and 29 of 2020, which was passed on 28th of September 2020, are limited to the Companies Act only and do not have any extended jurisdiction or applicability to other laws. So the amendments made and the reports which were prepared both in 2018 and 2019 by the Company Law Committee, of which I was fortunate to be a member, did not deal with any offenses under any other law other than the Companies Act. In fact, the Insolvency and Bankruptcy Code has a separate chapter on offenses and penalties, where the penalties have been given for various offenses, including for false information, for not observing the orders of the tribunal, for not complying with a resolution plan which has been approved, and they are criminal in nature. They will also have a fine, but both imprisonment would also be there in relation to some of these offenses. And there's a residual catch-all clause under section 235 capital A of the IBC, which says that if there are offenses for which no specific penalty has been put, then there could be a prescription under the central government orders or under the IBBI orders prescribing the extent of the penalties in relation to non-specified offenses. So far from decriminalizing anything under the IBC, the provisions still stay as they are. And I think this question is also relevant from another perspective, that though this is an indication of the Companies Act changes, it does not it does not mean that other laws which have criminal provisions or criminal consequences would stand ipso facto amended to the same extent as has been provided by the Companies Amendment Acts of 19 and 20. There is a major change which I thought I would like to mention at this stage. I'll cover it in the sixth question. Let me close there.
Thank you so much.
Mr. Desai, do you see any effect of these amendments on the proceedings that are pending before the authorities? And even if the appeals are dismissed, can the original quantum of penalty imprisonment be appealed again?
Well, let me tell you, as a person who's practiced in this area for several decades, it's a good sign when the government starts decriminalizing offenses, and I think it makes life a lot easier for the corporate sector. I must say that the bar has been a singular beneficiary of all these criminal law provisions over the last 30 or 40 years. But I must also say that over these last 30 or 40 years, I have shared many of my feelings on some of these provisions with many people who are probably part of your association to try and see if they could be modified. And this change which is coming about, both in the specifically in the Companies Act, and as I heard from our co-panelists, in the approach of government, I think is extremely essential and necessary as we progress along in this country. And having said that, I must also share some of my experiences in the context of what you asked me. And I hope there is a change in the approach of the authorities today. It's not as if decriminalization has not occurred in legislations over the last 30 or 40 years. I remember one of the early stages of decriminalization in some ways started in 1991 when the Gold Control Act was abolished, when the Import-Export Act was abolished and substituted with the Foreign Trade Development Act. As we went further along, we found Foreign Exchange Regulation Act was abolished in many ways and decriminalized because of the serious draconian provisions, and it got substituted FEMA. So we've had this trend along the way. Customs Act, where they brought in compounding, excise, they brought in compounding. So we've seen this very interesting trend, which has actually, in hindsight, helped business in many ways. It has brought about, a lot of ease in the pressures in which corporates actually conduct their businesses. But there's one area, and that is an area that you actually touched upon, where I hope there is a change, and I sense there is a change in the mood now, and I'm just hoping that that happens. And I'm sharing this from my experiences in the courtroom, is that despite the decriminalization processes that had got initiated, we used to see many of the old cases still languishing in the courts for a long period of time, for offenses which had been repealed, were legislations which had been repealed, for offenses where they provided alternative methods of punishment, compounding as was made available. We still used to see many cases pending in the courts. I mean, take for example, one of the areas where for the last nearly 20 years we are still seeing cases languishing in court is the Foreign Exchange Regulation Act, and I'm sure many of our viewers here are also aware of those realities. So what needs to be done as part of the process of decriminalization is that because government and legislation has felt that these punish offenses don't nearly need to remain on the statute book for the purposes of ease of doing business and ease of living. And I'm very happy to hear the phrase ease of living, because that's something which is very dear to all of us. It brings us constitutional values. Is the need to also apply the spirit of that amendment to the existing cases which are in the system. And instead of leaving it to corporates and business people to fight for dropping of those prosecutions and proceedings, is easy for government to consider withdrawing them rather than leaving it in the system. I think it has multiple benefits. I think it reduces the pressure on the justice system because as it is, we all know what the problems are in the justice system. So it straight away reduces the pressure on the justice system. It instantly brings about an ease of doing business and ease of living, and doesn't require corporates to sort of keep litigating in the courts. And I've had this experience for years where we've had to fight. And that's why we've got some very interesting law that gets developed in the context of the provisions of repeal and saving. And in what kind of situations is there a repeal? In what kind of situations is there a saving of an offense? When is there, if there's an omission of a provision, then does it constitute a equivalent of a repeal of a provision? So we all these nuances. But all this is very interesting legal jugglery. But from the corporate's perspective, I think government should, when they apply these laws and they bring about these principles of decriminalization, must apply the spirit and voluntarily withdraw the proceedings and not wait for courts to actually dismiss them. But that is one of the realities, and I would urge my co-panelists who are here, because I've seen so many cases in the ROC. They've obviously got the statistics. I think it's slowly improving, but I think there's a way to do it. And I agree with my what I'm hearing, that this we are seeing, and all of you probably are more closely connected with it, a change in the mood for businesses. There's a mood to try and reduce criminal law offenses in relation to many of these matters which are day-to-day affecting the business community. And if that happens, obviously, that's a great move forward for corporate sector, for the economy. But when you come, therefore, to the other part of the question, that even if the appeals are dismissed, can the original quantum of penalty and imprisonment be applied? Undoubtedly. There's a concept of a doctrine of beneficial legislation, where if the penalties and punishments have been reduced subsequently for the same offense, then it is the reduced punishments which should actually apply, if at all. So on the doctrine of beneficial legislation, one could plead that now if it was earlier punishable with imprisonment, but now the same offense is punishable only with fine, then courts can impose only the fine in relation to these kind of offenses. So you are seeing this, it's there in the law. We as professionals, of course, would of course enjoy litigating all this, but I think as government and as part of the process here that we stand for, I think it's important to extend the spirit of what is happening and improve the backlog in the system, because the moment all these cases start going out, automatically the courts get freed up for dealing with more serious and substantive matters which are also lying in the courtrooms. So, this is where I see, because I've seen it in gold control, import, export, foreign exchange, income tax. Of course, Negotiable Instruments Act, I believe the government is now re-looking at whether to decriminalize the provisions of 138. And if that goes through, then there was some interesting statistic that nearly 15% of the cases in the criminal justice system would be reduced if 138 is decriminalized and the cases are withdrawn. So, you have a very positive impact on system. It has a positive impact on corporate. I think it's a win-win. And I like the phrase ease of living. That will certainly bring about ease of living.
Certainly. Thank you.
Thank you.
Mr. Das, do you think there are challenges that the MCA would now face since certain offences have now been removed from the Companies Act and now will be enforced under specialized legislation?
Definitely, because when the new provisions comes into effect, for implementation of that, it takes some time, and also you need to face some challenge. You need to find out the way how to do it, all those things. So definitely it will be for initially it will be a little challenge for the MCA, but subsequently once we are used to it, definitely it will be streamlined and there will be no problem at all.
Thank you.
Mr. Shaw, so how will the decriminalization under the Companies Amendment Act 2020 be seen by the global investors and global corporations from a compliance and governance standpoint?
I think there are two parts to this question that you have raised, and one part of it which is very, absolutely not communicated to the business world, is that the specific provisions concerning foreign companies and registration in India, that is under section 379 of the chapter 22, has been omitted. And as a result of that omission, several significant provisions of the Companies Act become inapplicable. So just to sort of read out from the original section, sections 380 to 386, section 392 and 393 will cease to apply. So the filings and all the process that was required for enabling a foreign company to run its business in India are gone. And that has nothing to do with criminalization. It's a part of the amendment of the 2020 Act, because this will have far-reaching consequences on people's reluctance to file, if they are a foreign company, to file their records and file their details under the Companies Act prior to this amendment. So this is one of the biggest changes which have been brought about as far as foreign companies who require to comply with the filing procedures under Indian law, under the Indian Companies Act. Additionally, a new section has been introduced, section 393 capital A, where the government has the power by notification to exempt any class of foreign companies or companies incorporated or to be incorporated outside India, whether the company has or has not established and formed may, and when formed, may or may not establish a place of business in India. So this is again a very favorable provision for foreign companies, and wherever there is a flow over impact of of a consequence of doing business or supplying goods to India or supplying services to India. Now, as far as the question that you have raised to me, the decriminalization has one salient consequence on foreigners doing business in India. Almost all the provisions of imprisonment in a series of some 23 offenses under the 20 Act and 16 offenses under the old, the 19 Act, have been removed. So in a sense, they have been converted to a civil wrong from a criminal wrong, and all the aspects of imprisonment have been deleted, or rather have been substituted by purely a penalty, which is a monetary fine. In relation to the aspects of doing business in India, one of the greatest fears that have been expressed by promoters, foreign promoters or foreign directors, and anyone who's a key management personnel, key management personnel, is to be jailed in India, because the conditions of the prison in prisons in India is atrocious in comparison to the kind of living conditions that most of the advanced foreign countries have. You are seeing this kind of evidence being led in the Malia case, in the Nirav Modi case, where they are saying that the condition of jails in India are extremely poor, and India has had to file affidavits, show affidavits with photographs to show that the conditions of some jails, especially the Baikala jail, is not as badly, pictured by some of these accused. So certainly my impression is that global investors will certainly benefit from this provision as sort of decriminalization, and it will attract more business to India. That's
right, sir. So very important, sir. I think the point that you made, that awareness has to be created and the information should be shared. And I'm happy to, sir, inform that when we send the information about this detailed session, the certain diplomats of the foreign countries, the consulate and embassy, got very encouraging response. And I'm sure some of the trade attaches are listening to this. So as a chamber also, sir, we'll communicate this very closely, sir. Thank you.
Thank you. Mr. Desai, in fact, taking from what Mr. Shroff has just shared, since the decriminalization under the Companies Act is limited to decriminalizing of the compoundable offenses and doing away with offenses that are dealt with specifically under specialized legislation, what are the precautions that the corporate's management and the board of directors may take, especially to ensure that the risk that continues to exist in respect to these other legislations, is not really used as a via media or a backdoor entry to be able to take actions against them?
This is a very, very important issue for every India. And it really goes to the ability of corporates to internalize the need for good governance, rather than leave it to government to tell you how to govern your companies. I think the unfortunate reality which one sees in the last so many decades is every now and then we have what we thought were reputed corporates having caught themselves in difficulties. And the questions have always come up about the governance structures within such corporates. I think the first thing corporates must recognize is through the process of decriminalization, the government is giving corporates one more opportunity, if I might say this, to learn to self-regulate and learn to improve their own governance standards. You can't keep coming and knocking on the doors of government every time to decriminalize, only in a manner whereby the corporates stop governing themselves. To do that, you're going to have government coming and governing you, and you're going to have a lot of criminal law legislations. I don't know whether the last 15, 20 years has taught corporates the need for extremely high standards of governance internally. So what are these governance standards that you maintain internally? Because that's the only way you can protect yourself. You know, the offenses, I must say, which have got decriminalized, in my opinion, were all very minor technical matters. Okay, it was a cost burden on both the corporate and the government to maintain litigation in relation of these very minor offenses. So I think it was a good thing to just get them off the statute book, because they were really of no real significance in the process of governing a company. And these, you know, you had a statistic which said, oh, I've launched 500 or 1,000 or 10,000 prosecutions, but most of them were not relevant to governance. The substantive issues which corporates need to recognize are still part of the criminal law process. And if corporates really want to stay away from that, then you people need to figure out, otherwise you'll be knocking on the doors of lawyers a lot more. So how do you go about doing it? I mean, it's just about making sure that you have the highest level of integrity at every level as far as possible. But, you know, obviously this comes promoter down, management, key management personnel down. It's the highest level of integrity that needs to be put through. And how do you then keep ensuring and maintaining within the corporate structure? What are your own checks and balances that you have within your own corporate structure, which would ensure that you don't fall foul of some of these processes where today the government has let you off the hook by taking them out of the penal law provisions. And I think what you must do, and my recommendation is, I think corporates must still believe that there are offenses on the statute book. If you stop believing them, your governance structures will drop. If you keep believing internally that there is a criminal law liability, that anybody who violates any of these is still existing, your mindsets will change, then there will be necessarily an improvement within the system to ensure that you don't fall foul of all these issues. You know, I must say something, you know, and I agree with what Shardul just said about the global impact of some of these provisions. And one of the biggest fears is the fear of arrest. And I must say that, and this is something which I've shared a lot with the business community, with chambers of commerce over the last 6 or 7 or 8 years. I don't even know whether it has reached the years of government, but I strongly believe in the Companies Act, particularly in the Companies Act, because the Companies Act is a legislation which regulates corporate behavior, and corporates are necessary for any economy and GDP growth. It is essential for animal spirits, it's essential for entrepreneurial spirits to have corporates and businesses coming about. But you need to find the right balance between ensuring that these entrepreneurial spirits are existing and this issue of this fear of doing business in India, which Shardul just mentioned about. And what I was concerned about is the introduction in the Companies Act of the power of arrest. And it was not there in the 1956 Act. So from 1956 to 2014, the Companies Act did not have a power of arrest. Maybe times changed, but it got introduced as a power of arrest. And not only is there a power of arrest, and it's important because look at some of the business legislations. Some of the business legislation have no power of arrest. You don't have in the Companies Act till 2014, 13, there was no power of arrest. In the Income Tax Act, you don't have a power of arrest. These are legislations which are essential for keeping the mood of the business community or the community which contributes to the wealth of the country or creates the wealth of the country, that you don't provide the power of arrest, because there are enough other legislations which deal with deviant behavior of individuals. There are other legislations, but in these legislations, to introduce the power of arrest is to create a sense of fear for a businessman and a business community, because you've created a power in the hands of an authority which can be used. Not only did it do that, which concerned me, and I'm sharing these thoughts because if the Indian Merchants Chamber and our colleagues who are from the department hear the voice, because the spirit and the mood is to actually try and help business and bring about ease of business. The second thing that they did in the provision for the power of arrest was to introduce a bail condition which is parallel to the bail condition for organized crime syndicates of this country, for the narcotics suppliers of this country, for the terrorists of the country, which shocked my conscience. I mean, however much I've spent time on this branch of the law, there you need to find that need to balance the interest of the state with which includes the economic development of the state, which is why you have companies, you regulate corporate behavior, you encourage corporates to do more business, but do not create this sense of fear with this power of arrest. And what Shardul said about foreign investors and foreign companies, and I've had occasion to deal with such cases, is the concern that when we come here as investors, when we come in and invest in companies in India, and we sit on the boards because we are now investees and we have board rights, what is the risk that we take in relation to criminal legislations, in relation to the question of the exercise of the power of arrest? What is the risk to us? And that is something that concerns the investors. And therefore, my own view is, in the Companies Act, we should encourage and not have the power of arrest, and certainly not have the power of arrest with a bail condition of the type that we have in the legislation today. And that is something that I would hope that the chambers try to deal with it, because I have no doubt in my mind that errant promoters, because this is not about saving errant promoters will face consequences under the general law of the land. But we must have what I call the doctrine of the presumption of honesty when it comes to corporate India, and have a legislation where we must at least presume them to be honest when they're running their businesses, and leave the dishonest to be dealt with under the other laws of the land where they can be dealt with. So this is something which, as time progresses, and I see a mood, and I hear a lot about the mood of this government wanting to try and improve the conditions for the business community, is when Shardul said, and you asked the question, that what is the impact on global investors and global corporations from a compliance point of view. This is one area where, whilst this is a very positive move, I think there's much more that could be undertaken to improve the mood for foreign investors to come in here and invest readily. So, I mean, having said this, I also, in this context of governance, must raise 3 points for you. And this is my view again, and this is again a balance, whilst many of you may not agree with my point of view. And I think this is where I see a trend, and I think we should think about it. I find that there are 3 important provisions which got decriminalized in many ways. One is in relation to the prospectus, one is in relation to related party disclosures, and one is in relation to disclosures relating to beneficial ownership. I think these were 3 very important provisions where any amount of governance will not help, unless there is some amount of pressure from an external provision which puts the fear that make sure that your disclosures are correct, make sure that your prospectus has the correct information for investors, and make sure that you make your full and complete disclosure of beneficial ownerships. And I have felt that apart from anything else, if we talk about improved governance standards, my colleagues in the ROC will have, from their own experiences, found that these are three areas where there is an incentive for people to try and protect themselves and cover up. And if you give them only 50,000 and 1 lakh rupee fines, you are in certain cases trying to dilute the governance structures. So the balancing that needs to be done, as I've shared with you, I think the balancing also in three areas needs to be done at a statutory level by probably strengthening these three provisions, but taking away the power of arrest, or certainly curtailing the exercise of that power of arrest in matters and changing the bail provisions. This is my sense of some of these things. Sorry, I went a little beyond your question,
Wonderful.
but I thought it sort of is going to share a slightly different perspective, which help us.
Thank you, Mr. Desai. In fact, this is exactly, we are hoping that with the experience and the practical reality that we see on ground, these insights are the ones which are invaluable to us. And in fact, we will be looking towards the end of the session to have interaction on such issues. Yes, Saurabh.
Desai, if I can just in addition quickly respond. IMC Chamber is a part of the committee constituted by Ministry of Corporate Affairs, which is reviewing all the provisions of Companies Act and LLP regulations. So we will be very happy to take this up, and with the help of the senior officials who are with us today, we will certainly take this forward and see that this is given a patient hearing. Sure. Mr. Das, sir, how well you think is the Ministry of Corporate Affairs equipped to implement the in-house adjudication mechanism, and do you see if there is any challenge, any key challenge in this regard?
We at MCA, I don't think this is a big challenge for us in dealing with all these in-house adjudication processes, because if you go back to the provisions of Companies Act 1956, see, there are provisions where we are filing a lot of prosecutions. For that, we have to prepare the case details. Then we have to take the papers to the court, file there. We do all sort of acts for filing that prosecutions. So this is now we'll not be going to the court. We'll be doing it ourselves in our own system, where we'll take the support of the technology. E-adjudication process, everything will be taken into account. I don't foresee any major problem at MCA for in-house adjudication of all these offences.
Oh, brilliant.
Could you please share with us the risks and the pitfalls that you really see for the companies and the management? Because as just shared by Ms. Desai, the concern here is the fact that given that there is this relaxation, there is always a possibility for the corporates to view this as the seriousness of it in a little lax manner. So what are the essential ingredients that are necessary for the management always to understand in order for them to be able to ensure that they are not caught off guard by just simply feeling that the act has been now decriminalized?
I think to the question that you had raised to Mr. Desai, there are issues such as fraud, offenses against public interest, and non-compoundable offenses which are not decriminalized. But what has happened, and what has probably gone unnoticed again, is the amendment of Section 212 of the Companies Act regarding investigation into the affairs of the company by the SFIO. A new Section 14A has been introduced, which is of phenomenal consequence, and it's as big or bigger than the class action remedy which was prescribed under Section 250. What it says is devastating, and let me read. where the report under section 11 or subsection 12 states that fraud has taken place in a company. It's just a report, it's not a finding or decision. And due to such fraud, any director, KMP, other officer of the company, or any other person or entity has taken undue advantage or benefit, whether in the form of any asset, property, or cash, or in any other manner, the central government may file an application before the tribunal for appropriate orders with regard to disgorgement of such asset or cash, and also for holding such director, KMP, other officer, or any other person liable personally without any limitation of liability. So the mere mention of a fraud in a report which is filed in the process of an SFIO inquiry enables the central government to move an application to the tribunal, that will be the NCLT, to seek an order of disgorgement against any asset, against any property, against any cash. And this is by far the furthest reach in the principles of fraud and the normal principle where you're supposed to restore the property back to the company. Here you're saying that whether the property is restored or not, I can hold you personally liable to the extent of the fraud and without limit. It's an unlimited liability being imposed on a limited liability company. Directors don't run this on the basis of, I mean, what kind of liability are you going to pose on a director or a KMP that he's going to stop, taking up assignments in a company? No independent director will want to be part of such a process. And actually, even a person like me, who's knowing so much of the Companies Act, I have resigned from all boards. The risks which the Companies Act proposes or puts down now on paper are far more than what risk we have in running our own businesses.
True.
If there's a fraud or there's an injury to the public interest, or if there are offenses which are really non-compoundable, and an SFI inquiry, in an inquiry a report emanates, then this is not only going to have ramifications in India, but across the world. This kind of provision arising from an investigation only, which is not tested as finally proved, will enable the government to make an application, and the tribunal is authorized to order its disgorgement merely because fraud was stated, without proof, without cross-examination, without testing the same, and you order an unlimited liability. How is this going to be? I mean, this has not been really seen by the practitioners of corporate wrong in the light that when one reads the section, it's alarming.
No, it
So this is
definitely is.
really one of the risks I would identify to the companies and its management, that please be careful. Fraud has an enormous consequence against you if it is a matter within the realm of the SFIO. The second issue which I'd like to point out is that while these criminal wrongs have been effectively decriminalized, they are still liable to payment of penalty and fine. And what it says is that if in a period of 3 years, the default is recommitted, you have to pay double the fine. So that is also not a small kind of wrong, because there will be an occasion for a disclosure stating how many times you committed a compoundable, you committed an offense which was not criminal in nature, but which was adjudicated and resulted in a penalty. The reputation of the company is going to be tainted by all the actions which have been decriminalized, but which have been made easily determinable in an internal mechanism for doing this investigation. The third thing that I wanted to bring to at least the lawyers on this panel, or in the listeners community, that there is now a defined space a defined number of words in which you have to defend a show cause notice. You can't write a word more or a letter more. And lawyers who are used to writing briefs which run into thousands of pages are going to find it extremely difficult to condense their written submissions or their defense in a stated box which is provided in the response form under the compliance filing mechanisms that the MCA has already begun. So this is my view, that to sort of cripple a person's defense by a limited number of words, when you may have to plead constitutional principles, you may have to plead principles of Article 14, 21, the reading of the section itself, and the ability, they have also got the ability to deny you a right of personal hearing. They can say that we will decide on the papers that you file. So these are some parts of the law where I feel that there could be complications, and these also are matters which must be notified to the management, that whilst it appears great that there is a decriminalization and people are going to be charged fines only or as penalties, the flip side of this is equally tough, as Amit mentioned, that they need to polish up their governance. If they don't increase their standards of governance, the disclosure norms are going to kill them. They're going to have a very serious problem because they will be mandated to disclose all these issues in their balance sheets, in their prospectuses, and the standard of disclosure will be such that these would be highlighted. So the amount of errors that you made in conducting your business is going to be scrutinized with a microscope. And that is the real downside to decriminalizing, but because it expects an honest governance, it expects that that you will not go wrong. So the alarm bell that should ring in management, at least of public listed companies, is that yeah, these are important, because this provision, which I stated 212, extends to unlisted private companies also. There is no exclusion. A fraud can happen in a private company also, an unlisted company also. And the disclosure will come in the balance sheet, notwithstanding the fact that it may not be a SEBI level disclosure or an LODR, but it will apply across the board, across all companies, including a one-man company. So these, in my view, are serious issues for which actually none of us reacted. The CLC did not bring this to the committee at all. There are many provisions in the bills or acts now which were not placed or commented or discussed with the members of the CLC committee. And everything other than deciding upon which offenses should be decriminalized was the decision of the government. It was the making of an act for which there was no reference to the committee. So these issues that we are now seeing are as we are as innocent or as not knowledgeable of these issues which have crept into the law because nobody asked us, and it was not part of our mandate or scope. So there are some of these kind of issues, and there are too many across. If one sits and scrutinizes section by section, there are howlers in this act. I'll give you one more howler, which I think is there in the, just give me a minute. It's in the 20 bill. It's in the bill of 29 of this thing, where it's an amazing mistake. Under section 450 of the Companies Act, the punishment is a fine which may extend to 10,000 rupees, and when the contravention is a continuing one, with a further fine which may extend to 1,000 rupees for every day after the first during which contravention continues. The words liability to a penalty of 10,000 rupees, and in case of a continuing contravention, with a further penalty of 1,000 rupees for each day after the first during which the contravention continues, subject to a maximum of 2 lakh rupees, in the case of a company and 50,000 rupees in case of an officer in default or any other person shall be substituted. Immediately following this section, as a part of section 452, what it says is, provided that the imprisonment of such an officer, where is the imprisonment even the original act? The only wrong which was contemplated for 450 was a fine. And yet you have said, provided that the imprisonment of such an officer, as the case may be, shall not be ordered for wrongful possession. This is the section which contemplates wrongful possession, for which there is only a fine. Even now, it was never a crime, but they have brought it in as if it was a crime. So this is careless drafting, and it has become an act.
These insights are so valuable, and needless to say, are going to require a separate session to be able to, as you rightly pointed out, to bring these into forefront and have the regulators look at these, have a relook at these again. What I'd like to propose now, since we understand that Mr. Das, would like to leave a little earlier, because as we know, he's consented to be here despite of the fact that he's been unwell. With your permission, I'd like to just invite our expert, industry experts, to ask their questions, so that Mr. Das can, then leave a little earlier. I'd like to now invite Mr. Suresh Kotak, Mr. Shailesh Haribhakti, and Mr. Narayan Shankar to ask their questions to this August panel. Just by way of introduction, Mr. Suresh Kotak has kindly, who has been the past president of IMC. He is also the chairman of Kotak & Co, and also has great interest in alternate dispute resolutions as well. Mr. Kotak, would you like to take the first question?
Yes, please.
Thank you.
I would like to understand that in-house jurisdiction, in-house adjudication, which has been discussed, does it have also some kind of provision for alternate dispute resolution process so that so many things can be resolved through ADR, whether such thing is provided or such thing would be possible? That is number one. And my second question would be, the Section 8 companies, how does the new law have impact on Section 8 companies? Thank you.
So, sir, first I'll answer you. For the in-house adjudication mechanism, for the alternate remedies you are asking, we'll go by the whatever the provision says. If it says that it is to be adjudicated by the ROC, it has to be said. So we'll go by the provisions of the Act. As regards the Section 8 companies, that I'll just let you know that, because immediately I was down with fever, so immediately I don't have the relevant material with me. That I'll come back to you.
That is absolutely fine, Mr. Das. We can revert on that particular question. Now I'd request.
Can I address one matter which Suresh Bhai has raised? I think in the existing Companies Act, Section 442 has the concept of a mediation and conciliation panel. It is a part of the existing Principal Act itself. So, whilst arbitration is not an alternate dispute resolution procedure, the central government is mandated, and there are rules also called the Companies Mediation and Conciliation Rules, under which the authority, if required or petitioned by any party, is bound to follow the procedure of taking the matter to a conciliation as set out in Section 442 and the relevant rules. There is, however, no provision in the internal mechanism to really refer a matter to arbitration or any other alternative mechanism, because it is in the main act. The internal mechanism is an adjudication of fine process. It is not a settlement. It is on the assumption that a wrong has happened and you are quantifying the penalty, or you're hearing all the possible defenses against a wrong, an offense, which is not a criminal offense, but a civil wrong. So to expect an adjudication, or rather a arbitration or alternative dispute mechanism between a regulator and a company or its KMPs is not possible. It does not exist in the SEBI law, and these provisions which have now been brought in are already there in existence in the SEBI law for more than 3 decades. So this is not something new which has happened. All that they have done is take away the jurisdiction of the magistrate and bring it into, or the other criminal system courts, and bring it into an internal, where it has been decided by the government that these are not matters of significance in the sense you need to jail somebody or you need to decide whether it is compoundable or non-compoundable. It is enough to pay a fine and move on in life, because a fine is supposed to be a compensation of some sorts, especially in compoundable wrongs, that the government has fixed it. It is quite strange, and I don't know why people have not noticed it. The fine was higher in the 19 Act and has been diminished in the 20 Act. What happened between the first report of the committee and the second report, which had prescribed these standards and to which government signed off? So the anomaly between the change between the 19 Act and the 20 Act, where the penalties have been brought down significantly, has not been explained. It's probably public pressure that has caused these fines to fall down, and it's quite alarming to us that our recommendations, which were unanimous, have been changed. So this is to answer Suresh Bhai.
Now I'd like to request Mr. Shailesh Haribhakti, Mr. Shailesh Haribhakti is the past president of the IMC Chamber and the former chairman of Haribhakti & Co. Mr. Haribhakti is on the boards of various companies, institutions, and committees which are set up by several government, as well as educational and social institutions. Good evening, Mr. Haribhakti. Thank you for being here.
Pleasure.
Please go ahead.
I think, let me start by saying that this has been one of the most impressive, frank, free, and data and knowledge-led interactions that I've been in. So thanks to everybody. I heard all three key speakers, Mr. Das, Amit, and Shardul, speak about e-governance, about digitization, about making sure that your governance standards are high. And I can see no other option, given the complexity of the law that we've already seen, to enable that governance for anything other than digital properties to be used. My question is that if there is that apparent one step forward by corporate India, that they will adopt digital means for compliance. And we've already heard Mr. Das saying that they use e-governance adjudicate. Then is there a data governance interchange between the people who are complying with the Companies Act and those who are administering it, which will mitigate and reduce the room for longish disputes? And therefore a follow-up question is, can we put timelines on how quickly these matters ought to be closed once they are filed, so that litigation can get reduced and resolution can happen and people can again breathe easy?
Let Mr. Das go first on this, because he has to leave, and then we'll, if we can't, we will explain.
Nope, we'll take the pressure because the major, if you look at the violation, the in-house adjudication mechanism, section 92 and section 137 is a major section where we'll get lot of, maximum number of companies violating the provisions in filing their returns. So we'll be definitely taking the help of technology to address these issues and do it in a timely manner. Okay, the rules also prescribes that the adjudication process has to be completed in a time bound manner. So definitely will do.
Thank you, sir. Thank you.
Felipe, I just wanted to add two things. Even the Insolvency Act had a deadline of 270 days. It got extended to 330 days. You tell me which case, which is of complexity, ever got adjudicated in this. And the courts have themselves given a free hand by stating that you cannot, it's a direction and not a statutory mandate. Time is what the time courts can give. So if that is the principle, one cannot really put a ceiling on exact times by which the proceedings need to end. This is one. Then if it is a sort of 1 + 1 must be 2 kind of situation as a compoundable offense or as a penalty where they prescribe the levels of penalty, then if there is an admission in a sense of when you compound or when you go to the court, you already considered that a offense has happened. It's just a matter of determining the value, and which can certainly be done through a e-court or an e-tribunal or an e-adjudication by an internal officer. They have what is now called an AO system, which is the adjudication officer. So whoever is a registrar or RD might be classified as a AO, depending on which capacity or at what level the adjudication is taking place.
Absolutely. Thank you, Shadhu. Thank you very much.
But the actions of fraud and all that will still have a full trial.
Yes.
There's going to be no shortcut to that. It will be before a special court and not a magistrate now. That's again a change brought about by these two amendments, that it first was a junior magistrate or a metropolitan magistrate. Now it has been bumped up to a special court for which there are provisions in the Act.
But the most difficult one is 14A, which you pointed out, Shardul. That is the most fearsome,
So there are two places, Shailesh Bhai, where there is unlimited liability. One is section 212, and the other is in the class action provision of section 250.
Oh.
It's unlimited liability.
Unlimited. It is.
For a chartered accountant, for an expert, for a KMP, for a board member, for an auditor.
Absolutely.
So two places where we have an unlimited liability in a limited liability company.
Yeah. That's very, very worrying.
This, Amit?
I can only share one experience, which is all right out there in the public domain. It just keeps coming back to me, and this is a issue which overlaps with foreign investors. And this was fortunately it was this new companies act was not there at that time, but this was the dispute and litigation that took place between Iridium Inc., Iridium and Motorola Inc. I think it's a celebrated case amongst the corporate sector in India. And I just sort of highlight, when you talk about fraud, and I just sit back and I'll give you one or two thoughts which come to me. But if just to highlight to some of the people who may not know what that matter may have been, because this was a dispute sometime, I think in the about 15 years ago, where Iridium was raising capital across the world. I think this was in the late 90s, in relation to a brand new technology where they were going to create a constellation of satellites in the telecom space, and they were essentially, they had there was a technology which Motorola had to manufacture and make a special type of a mobile phone, which could actually link up with this constellation of satellites. And you could probably speak to anybody, anywhere, on any part of the world. This was late 90s, just around the time when you were seeing GSM coming in. And this new technology of GSM came in. So Iridium went around the world, raised billions of dollars of capital, and within 2 or 3 years, it went into insolvency. There was a Chapter 11. And it was because there was competition with the new technology, which resulted in this particular form of technology not being viable anymore. So India being India, we were the only country in the world where a prosecution got filed for cheating before a magistrate's court. 420, that you misrepresented to us that this technology would work in this particular way. And a magistrate issued summons against the entire board, Motorola Inc. and the entire board of Motorola Inc. You know, all the American executives and all. And we spent several years, because then there was a civil litigation. Many of you might have been connected with it. I was connected with the criminal law litigation that went on. We then went to the Bombay High Court. We were successful in convincing the Bombay High Court that this doesn't constitute a fraud, because what is cheating? I mean, it's a form of fraud, and I worry about it because of the language of fraud that's there now in the Companies Act. And you look at some of the provisions and the ingredients of it, it's very similar to cheating. So it's fraud. So he said that this is not fraud. It went to the Supreme Court. The Supreme Court reversed us and said, no, it's a triable issue. You must go to trial and prove whether it's a fraud or it's not a fraud. And this actually resulted in ultimately the dispute getting settled. And India was the only company which probably realized a certain amount of money outside of a Chapter 11 proceeding. I mean, there was a Chapter 11 that was going on in the United States. Now, when you look at this kind of an example, and I think to myself that would Elon Musk ever want to invest in India with a SpaceX? I'm just asking this question because, you know, this is new technology.
All these satellites.
Yeah, this is new technology. People are putting in billions of dollars to decide whether a rocket will go to Mars and whether there is an opportunity to make some, you know, make a commercial enterprise out of this whole business of, you know, sending a rocket to Mars. I don't know. But if it was India, and in fact, I worry, because this is where entrepreneurship in India can be very easily killed. That this in India would be a fraud. Because they'll say, oh, you should have told us 100 million things about new technology, but you keep learning with new technology. There's competition that comes in. You learn from your mistakes. But there are entrepreneurs who put money behind it. Take the COVID vaccine. I don't know how many people have taken up money from all kinds of investors and how many will succeed and how many will not. Is it a fraud? It's very easy to allege a fraud in this country. And I worry, in fact, when Shardul pointed out 14A, because, you know, I'm often told that, you know, I create a sense of fear amongst clients, but I didn't show 14A. I said, well, you know, I've seen the consequences of the exercise of the power of arrest. And I've heard corporate sector feeling the fear of that particular power of arrest which exists in the book. This particular 14A, I mean, and since we are now talking about it, also let me tell you, because it's something which government really seriously needs to look at. Over the last 6-7 years, we've seen the interplay between the provisions of the Prevention of Money Laundering Act and other legislations. Now, 447 is a predicate offense under the Prevention of Money Laundering Act. So you have a situation where, and this is, you know, overlapping with the question that, I mean, Radhika was telling me, I said, what's the scope of this conversation? She said, please make it freewheeling, because we are here to get your experiences and understand, you know, where we should ask IMC to lobby. My concern is that you have a legislation, which is the Prevention of Money Laundering Act, which has the ability to go and attach the assets of people. It's a form of disgorgement. You then have a 14A, by which that very same asset, you go to the NCLT, the tribunal, and then say, now I'll attach that budget for disgorgement. So the poor promoter, director, key management personnel is going to be running between a 14A application and all his assets attached, which is very, very unfortunate, and a PMLA and a Section 5 and a Section 8 attachment. And he's going to spend his life with no monies to fight a litigation, no money to go and pay his doctor his medical bills, no money to live in his house and eat his food, because there's no provision in any of this for living expenses. And what we have seen, I'm sorry to say this because it's important for all of us in the context of our constitutional values, that in so many of these matters, we are seeing that the tribunal goes and attaches assets, even though 14A was not there. And then they say, then parties had to go and apply saying, but I can't even afford my living expenses. So there's a release of some 50,000 or 1 lakh of rupees a month. And that matter was in the Supreme Court because that was a larger challenge. And people were unconnected, independent directors of a company, very, very reputed people. I mean, I won't mention it because probably everybody here knows them, unconnected with the fraud that had been committed or alleged to have been committed in the company. All their assets were attached. And these were independent directors. So at one level, you talk about the decriminalization, which is a step in the right direction. But if we want to ensure that the corporate sector is vibrant and thriving, then encourage the independents to bring in good governance standards. Everybody can make an inadvertent mistake, but that is not equal to fraud. But the trend is to go after everybody without checking. And this particular provision of 14A is exactly what happened there. Without any material of fraud. In fact, in many ways, the affidavits that they filed showed that they did not participate in the fraud. They knew nothing about the fraud. Their assets were attached. And today we have a statutory provision which says, I say there's a fraud, therefore your assets must be attached. And as Shardul rightly pointed out, he says there is no cross-examination, there's no ability to bring your own evidence on there. All the directors of the company's assets will be attached under 14A because all that they say is an authority will come and say, I allege fraud. Conversation over. And what is fraud? Is Motorola and Iridium a fraud? Is Elon Musk a fraud? Is any new technology a fraud? It's easy to allege fraud in this country. Because the elements of fraud, if you go by the traditional principles, are very difficult to establish. It's very easy to allege.
Amit, the slight difference. Here, the investigation has to lead to a finding of fraud.
Yes, yes.
It's a one-sided investigation, but it's not the same
I'll give you
thing.
my experience. I'll give you.
I'm agreeing with you.
And I've argued this before the Bombay High Court. It's also in a sense sub judice because it's not in the Supreme Court, but it's a matter relating to this very authority here. Is in the case of the auditors. There are three punishments that an auditor faces. He faces disqualification under 140 because of an allegation of fraud. He faces a virtual life ban because of the NFRA proceeding. And he faces a disqualification and a life ban on conviction. So the auditor under the statute can be prosecuted and punished 3 times for fraud. One under 140 at the NCLT level, one by the NFRA for his license, and one in the criminal court under section for the offense of 447.
Now civil court.
3.
So 4.
How do you bring about the ease?
Under 212, 14.
No, and now you have 14A. And I must say, 14A was invoked against some of these people, and some of them were unconnected. So to use these provisions, I mean, the point is the Companies Act legislation is here to ensure that companies thrive. It creates economic value. It creates economic growth. It creates wealth for the nation. But the fear, and this is where foreign directors, foreign investors, apart from Indians, of course, but Indians have got sort of, this is becoming a part of their way of life. But it's not so for the foreigners who bring in their invest money, are very concerned about things like this.
Absolutely. Thank you, Amit. Fabulous.
And government has to work together to find the right balance. There are
I think that's
errand, and nobody disputes that. Action must be taken against the errand. Nobody is doubting that for a minute.
But the problem is perspective. This flows from one perspective that decriminalization should happen, but all the surroundings are against that process.
Yes, that is the reason why my
surrounding that bundle is gone wrong.
Is my concern, as Mr. Das nodded when I said it, is that offences which are decriminalized were the most irrelevant offences under the Act. And there is a need to bring a balance. Even if you don't want to decriminalize it entirely, there's a need to bring out a serious balance in order to ensure that people come in and put money in companies in India. That is what is important.
We have added disincentive.
That strong message to the investor community that India is a business-friendly place.
Thank you.
But
I'd like
Mr.
to
Das has to carry
now,
the message to government. I mean, it's and Shardul, of course, sits on so many committees. So you
Yeah.
need to.
But they don't bring us into the loop on these things.
Yeah.
No? They only bring us into
That's
segments.
why I very casually mentioned to you that if you invite some lawyers like us, we are not here to protect the guilty. We are here to ensure that the right thing happens for the country.
That's true. True.
You didn't take guidance from the committee. Didn't want the perspective of experienced lawyers here to say, knock out these, retain some of those, but also bring the balance in the definitions because of all these experiences that we have seen.
Yes.
now I'd like,
Sorry, go ahead.
no, not at all. Thank you very much. Now I'd like to invite Mr. Narayan Shankar, who's the Executive Vice President and the Company Secretary for Mahindra and Mahindra Group. Mr. Narayan Shankar is also very active and participates in all the industry forums, regulatory and education forums, and makes an invaluable contribution on account of his experience. Welcome, Mr. Narayan Shankar.
Thank you.
A pleasure to have you here. Please go ahead with your question.
Okay, so I'll make it quick. First is just, I of course have three questions, one for Shardul, Amit, and one specific comment for Mr. Das and Mr. Shah. But let me first quickly in half a minute just make a mention about what is one or two misses which Companies Amendment Act did, but was recommended by the CLC. One important recommendation which was made was to limit vacation of directorship only to disqualifications under 164(1). What it means is if vicarious liability should be removed from the provisions of vacation of office, that is 164(2). Of course, there is a mention that this will be taken up in the second phase and not in the first phase, but specifically on account of COVID today, and if you are not able to, if there are any other major issues with a lot of independent directors resigning, this would have really been a good that just because of vicarious liability of one, you do not lose your office in the other. One important positive for industry is undoubtedly payment of remuneration to non-executive independent director, even in case of loss or inadequacy. That was always a problem for industry, specifically in the startups and areas where the gestation period was large. Today, we are waiting for the amendments to take place in Schedule 5. And once that is done, I'm sure we'll be able to remunerate non-executive directors also aptly. The first question I have for Shardul is, sir, the liability of directors today, one of the ingredients of liability of directors for a non-executive independent director is knowledge attributable through board process. So as far as knowledge is concerned, you'll have two types of knowledge: actual, no issues at all, agenda, minutes, presentations, all that is fine. The key issue which is being faced by non-executive today major is in a lot of the prosecution in the new cases which is coming out, many of them which is in public domain, is the implication of constructive knowledge. And constructive knowledge is something which the director ought to have known, or which imposes an obligation on the director to conduct an inquiry. So to what extent it is right and how would courts really balance it? And the second connected question is, while in India under the Companies Act 166, you'll have clear duties enshrined in the Companies Act itself, whether it is duty of care, diligence, loyalty, but it can still only be generic. It can never be all encompassing. To what extent there is still scope or room for the BJR or the business judgment rule to still apply to such cases, because genuine errors in forming judgment is always a possibility. And the whole concept of BJR is, how do you balance protecting interest of shareholders and protecting statutory right of a board to run the company without fear? So hence, unless if there is gross violation, or if you say there is connivance or there is fraud, to what extent I made a mention about constructive knowledge and genuine errors in forming judgment. To what extent would BJR also apply? Would love to hear your views. After that, I have a question for Amit and then, but I would love to hear Shadu.
may I just, I apologize. I just want to make a point here. Mr. Das has just indicated on a message that, he's a little unwell and he
Okay.
needs to leave early. So would it be okay for the panel if we take his question first, simply because, he would like to leave a little? I apologize to interrupt in between in this. So, Mr. Narayan Shankar, could you please
Definitely,
ask?
definitely.
Yeah.
So, Mr.
Thank you
Shadul,
very much.
after Mr. Das,
Yeah,
I'll definitely come, but we'll be
yeah.
waiting for your
Thank
answer, definitely.
Yeah,
So,
definitely.
Mr. Das and Mr. Shah, first of all, compliments. I think government is taking the right direction, stricter enforcement of law. In fact, there is MCA version 3, as well as today you have got a project which is really going to ensure that every form which is being filed is going into STP, that is straight through processing, which clearly is going to free the machinery of ROC and ROD. They will have much more time in stricter enforcement of law and prosecution, and lesser amount of time is going to be spent, and over a period of no time in approval at all. Also, compliments for the introduction of compliance management system for monitoring non-compliances. Last but not the least, what really complements decriminalization is your adjudication process, because this has been a long standing request from industry, is to say that for trivial offenses, or if there is a form which is not filed, don't make the director sit outside the office over there along with others. So e-adjudication to a great extent really will help. Just my question is, when is version 3 and e-adjudication going to be completely online, and when are you going to go? What is the time frame which you're looking at, so that industry gets a hint of when it will be going 100% e-adjudication?
Thank you, Mr. Shankar. Thank you very much for your words. It is going to take some time. Where we have recently changed our service provider, they're working on it. It will take some time to for the e-adjudication process and the entire change in the V3 project. So it is going to take some time.
Great. Thank you, Mr. Das. Really appreciate it.
And Mr. Das, thank you very much. We understand that you would like to leave soon, so we are most grateful that despite of the fact that you were not well, you joined us. It's been a pleasure, and we look forward to continuing this with you and our panel in another session soon,
Sure.
where we can continue. But
Thank you so much.
Thank you so much, sir.
I'm really sorry for not able to attend the meeting completely. Mr. Shroff, thank you so much. Mr. Desai, all the participants, thank you so much. I look forward to joining another session of IMC.
Definitely, sir. Thank you very
Mr.
much.
Das, since you'll be leaving, can I just quickly, on behalf of IMC, take the consent of all the panelists? We would like to post this video on the IMC YouTube. So is it fine with the panelists? And since Mr. Das is leaving, can I have your permission, sir?
I'll check up with my RD, sir. Then I'll get back.
Okay, fine. All right.
Thank you very much, sir.
Wish you a speedy recovery.
Thank you, sir.
Thank you, sir.
So getting back to Mr. Shankar, your query,
yeah.
I think I'd just like to read section 149, subclause 12, and then from my understanding of the law, try and explain why this is even beyond the business judgment rule. I'd like to rely upon two decisions also. The decision in Satyam and Metas on the business rule, and what is happening in total contrast in the ILFS group of companies. So you have very, very contrasting positions. Firstly, what section 149.12 says, notwithstanding anything contained in this act, an independent director, a non-executive director not being a promoter or a KMP, shall be held liable, so that's the positive part, only in respect of such acts of omission or commission by a company which had occurred with his knowledge, attributable through board processes, and with his consent or connivance, or where he had not acted diligently. Now, the business process, somewhere in a pile of 1,000 pages which are delivered the night before for independent directors, some element is pushed in. You had, for example, if you take the case of Satyam and Metas, you wanted to transform a software company or a services company into a property company, and you wanted to cross-invest in that. Now, the first question which any reasonable director would ask is why? Why would you want to do this, and not some small amount, but almost the value or little more than the value of the loss which was happening in Satyam was the game plan. And this has all been confessed by Ramaringam Raju. So that is the smell test which normally directors are told to apply from their common sense as a reasonable purpose. You are not an independent director is not like an auditor or a bloodhound. He has not tried, he has not to try to act with such suspicion that everything has to be, first explained from scratch, examined from scratch, somebody certifies that this is fine. Business can't run on that. There has to be the concept of business judgment, which is why the expression the words which are used is knowledge. Now, I may not have knowledge because I may have got to read the paper the night before. Attributable through board processes, which means it have been raised up at the board. It would have been discussed at the board, not just because it is somewhere dug in the minutes or in the agenda. It has to be actively discussed if I've had inadequate time to react or to understand the processes. And with his consent, which means he must have voted on it, either innocently, in which case it is his consent notwithstanding that he had poor knowledge or he didn't exercise reasonable judgment, or connivance, which means he was in it. Connivance would mean that I actively gave my consent to do it. They have used the words differently, consent or connivance, or where he had not acted diligently. So the last expression is actually where the reasonable test of due diligence, which is also a duty of the director under 166, has been done. So the business judgment process is embedded in these expressions. Let me take two diametrically different views. The Satyam board had very eminent independent directors. They got sued in a class action in USA. They got sued here also. They had a DNO policy. The Delaware court in USA, when the claims were raised in a class action, dismissed the claims against the independent directors, saying that you have not shown connivance, you have not shown consent, you have not shown knowledge, you have not shown omission. You can't just bring them in because they happen to be on the board. And they did discuss, and they temporarily shut their mind. They didn't take the consequence of the fact that a software company is moving into a holding company position as a real estate company. That should have hit any person. That was the only mistake in judgment that they committed. So all the independent directors who were on that board were discharged by judgment at the outset, not through a trial. First day, when they raised this question that, look, we don't know why this happened. They got a stricture to the extent that how can you say you didn't know what you did, or how did you apply your mind and give consent to such a dramatic change in business purpose? Did you not have the smell test applied for yourself? And you take the contrasting position in relation to ILNFS, where the independent directors are treated as party without any proof of connivance, without any proof of consent, without any knowledge, because the kind of reports which have come out proceed on the footing that it's only these 4 people in the company who knew. The rest was all assurances given by these people that everything is hunky-dory. Auditor's report is hunky-dory. How are they going to sit and find out fraud? But they're put in because of the same generic brush of fraud. So it depends upon, in many ways, I think it's a toss-up. It's not a certainty. One can't say that it will be this way or that way, because it depends on the extent of the fraud. I think the overwhelming loss in ILNFS has really driven the extreme end where government has had to petition the company law tribunal, which was not the case in Satyam. So I think the sheer size of the matter sometimes decides the output, and that's what's happened in my view in the ILFS matter. Amit?
Sorry, 1 minute.
Yeah. Mr.
Yeah, thank you, Mr. Shroff. Really appreciate. And of course, I was more referring to the latter one, the last cases, where although they have, the moment you're part of a decision in the board, the consent is deemed, because attribution means that you're consented to.
So but I can say two things. I can say two things. It was in the agenda, I absented
absolutely.
myself.
Yes.
If I'm absent, am I consenting?
Once you get the minutes.
Has it been proved that the minutes have been approved at the next board meeting where I was present and I accepted the minutes? If I was absent, how do you proceed with a statement of my consent?
Yeah.
And if it is not even raised and treated as a routine matter of holding company and investment, nobody's going to understand this whole fraud of changing that there was a hole and that it was required to be filled in by real estate, and the realization from that real estate would fill in the whole of the software company.
Absolutely.
None of that was evident. The only smell test they needed to apply is, why are we moving into real estate? That was the only question they missed. But otherwise, they were certainly not liable as independent directors, and the court said so. The Delaware court said so. And then they relied upon that dismissal in India.
Thank you, sir. My next question is for Mr. Amit Desai. Sir, with what has happened recently in the Vizag gas leak, in LG Polymers case and the other 1 or 2 cases which has happened, safety, of course, is back in boardroom discussions. But the key questions, in fact, even again coming back to non-executive directors and the board as a whole, is that to what extent can non-executive independent directors be prosecuted if there is some poor design of the tank, there was inadequate refrigeration, there was some wrong mixing systems which were there. If the board has appointed an occupier under the Factories Act, if the board has appointed a proper manager under the Factories Act, they have broad disaster management control systems, and broadly reports come from the occupier and manager, and it is placed before. When broad processes are there, but when such disaster happens, how fair it is for prosecution en masse for the whole board, sir? And would love to hear your views.
Well, Mr. Shankar, you know, what I find often is that the law is clear. It's a question of how you implement it and who is the individual implementing the law. So if you divide this into 2 parts and you ask me what is the law and what should the law be in the context of criminal law liability, principles are fairly clear. The criminal law liability essentially works on the principle of actual knowledge. Diligence, absence of diligence is a circumstance to show a mensrea or a state of mind, because ultimately there is everywhere a duty of care. And if you are then not showing that duty of care, then that is a form of a mensrea which is acceptable for certain types of offenses. So again, it moves from offense to offense, where there are some offenses which are very serious, where the quality of the state of mind is much higher, depending on the nature of the offense, gravity of the offense, and the punishment that's there. And for other offenses, the quality of the mensrea or the state of mind is much lower. So there's a whole spectrum. But mensrea, nevertheless, is necessary for all these types of offenses. There is a series of judgments which very clearly settle the position in relation to directors, non-executive directors, and in exceptional cases, even the executive directors. The non-executive directors are entitled to exit a proceeding at the inception, at pre-trial, because there is a presumption that they are not involved in the day-to-day management. Now, there is this presumption that they are not involved because therefore they don't have knowledge. Because those who are involved in day-to-day are presumed to have knowledge. Those who are not involved in day-to-day are presumed not to have the knowledge. So unless there's some specific fact, which is through a board process, which is established against a non-executive director, the knowledge is attributable, then certainly the liability arises. You take the case of safety, which is back in the boardroom after 30 odd years, is again that the principle of law is fairly clear. You're right. Ordinarily, it's the responsibility of the occupier, it's the responsibility of the plant managers, it's the responsibility of the people who are the experts who are actually running the plant, who are responsible and liable for the events which take place in a factory. That is the legal position. There are decisions to that effect. Diligence can also be exercised through means of good delegation. So the concept of diligence includes good quality delegation. It's not anathema to each other. And that is why when we also say that for executive directors or managing directors, if we are able to establish that the quality of delegation was high, in the sense that you did a proper process, you identified the right people, they are the ones who were then appointed, then you find that even in these cases, the managing director and executive director has an escape route from the liability ultimately. The only difference is he may have to go through the process of a trial to establish how he has exercised due diligence in this context. So as Shardul rightly put it, he says that the concept of diligence is very much there because it shows that there is a question of if you have exercised diligence, then there's an absence of the mens rea. If you failed to exercise diligence, and then there is a question of the extent of that failure. Is it in the realm of a civil wrong or it's in the realm of criminal law? So if it's a gross failure, then you may come within the realm of criminal law because there's an element of recklessness that as a matter of law gets attributed to that conduct of the not following, undertaking a proper diligence in the next steps that you take. So it becomes a fact-oriented question. But the principles of law are fairly well settled, that you need to have these distinctions. The business judgment rule that you mentioned is a clearly acceptable rule within the realm of fraud and criminal law. I must tell you that, in fact, even in the police manual, the CBI manual, the business judgment rule is a part of the manual. In fact, the manual, in fact, said, because what happens is that CBI, as you know, undertake a lot of investigation into transactions, commercial transactions.
Yeah.
And then they make a determination as to the commercial transaction is a fraud, is it an abuse of power, etc. So they do an investigation into the transaction. But even they have been told, and it's in their manual, that if there is a business judgment that has taken place, then it falls outside the realm of criminal law. So the business judgment rule is an established principle. The challenge that you face is the application of that rule. And as I often say, that the difference is that how does and to what extent does a police officer or a station house officer understand the business judgment rule? Because he's a police officer, he's not a businessman. And how do you determine what is business judgment and how that you have exercised it in a fair manner or if not? Because he's not an expert on business. And as a result of which, there are times when you find that although they make the effort to try and make an assessment, so there is a common sense behind it, they make an assessment, often they miss it, and therefore you find proceedings that are initiated, and it's ultimately through trial that you establish the business judgment rule and you are acquitted. I mean, in some ways, and just an example in point, which is a live memory for all of us, is that whilst we may have our own perceptions and suspicions about the 2G scandal, we must remember that in the end of the process of leading all the evidence over a period of whatever 3 or 4 years, when the judge looks at the evidence with a microscope and says, I'm acquitting, parts of it are part of business judgment. Parts of it are about the inability to prove the allegations that have been made. So you will find that there are these elements which do come into play because there are lots of structures. There are law firms like we have here, one of the best here, who will guide all of you to say that this structure seems to be in accordance with law. And I find that today there are times when agencies come in and say, I don't agree with that structure. I think it constitutes an abetment. So there is the view of a police officer who thinks that something wrong has happened and then wants to challenge the structure and say that it constitutes an abetment. And there are the transactional lawyers like Shardul's firms and others in the country who, after a proper analysis of the law, believe that this is in accordance with law. But then it's a question of, again, going into trial. But the principle of law is clear. It's a harassment that you face which creates all these perceptions. And that is really where the real problem is, this initial nuisance value of going through the process of an inquiry, an investigation, a commencement of a proceeding where independent directors get dragged into prosecution and criminal courts and unnecessary investigations. And they are not interested in all that. They come in with a sense of a desire to contribute from all their values and all that they've learned elsewhere, come to the board and share their perception of what's happening in relation to a company. And then they face all these problems and they say, you know, why do you want to get involved in all this? So as Shardul says, now that 14 is there, he resigned from all the boards. He doesn't want to get into even an initial inquiry. He said, I don't want it. And this is unfortunately where these provisions impact industry. Because the value of an independent director is unparalleled in many ways. That you people with all your experiences know when you run businesses and you have perspectives which come from outside and how it changes the way in which you may want to do a transaction or do a acquisition or whatever it is. And it's invaluable when you get some of these. And as Shardul said, the Satyam board had some of the finest minds sitting on that board. Even in ILFS, some of the leaders of industry with such great, enormous experience sitting as independent directors are now, you know, concerned because they're facing all these inquiries and investigations.
They're disqualified from every company.
Disqualified. And they say, why are we now sitting on boards? And you lose, through this process, corporate India actually loses the benefit of their
knowledge
contribution to these companies.
But Amit, a slight variation
about implementation and not the law. That's the real issue.
A slight variation because of two judgments in India: the Shriram Fertilizers case and the Bhopal case, where the rule of Rylance versus Fletcher is an absolute rule, and where it presumes that if it's a dangerous chemical which by escape is capable of huge public injury or bodily harm, then the principle of mens rea, principles of knowledge will not apply because it's an absolute rule.
Matter being argued, Shardul, right now.
I agree, but I'm just saying.
but I as a lawyer who's in this area, I have always had this issue that the Rylance versus Fletcher rule is a rule of civil law. It's not a rule of criminal law.
Criminal law, agreed.
And it is.
But I'm just saying that this is the defense, which is rather the offense which is being taken by government. That is especially in the LG matter. That's how the government raised it. It was not a private complaint.
That is the problem.
It was a governmental complaint.
Jurisprudentially, it's a civil law concept.
Agreed.
But it's optically very nice to raise it.
Even in the Supreme Court in the Shriram gas, basically it was treated as a civil wrong for compensation. It was not treated as a criminal wrong. In fact, Anderson in Bhopal got complete freedom. He was not, though he was the global CEO, he was not prosecuted. Case was filed, but ultimately in the settlement, it was dropped.
But I think the challenge, as you said, Mr. Shankar, is really more about how do we go.
Magnitude makes a difference. If 3,500 people die in Bhopal, nobody in his right mind is going to say you are innocent.
ILFS and other cases where their NCLT, the authorities made an application for attachment of their assets, and the NCLT was passing orders, and then it became very difficult because they had to go and apply for they couldn't even maintain themselves. I mean, all their bank accounts were frozen. Yeah. They all, all of them are all friends and colleagues of yours, but you see the concept. This is so it's implementation. The underlying jurisprudence may be all right. I mean, when you look at it, but it's the implementation, because you give them the power, and then you see where it goes, and that's where you need to have in government probably a more prescriptive method of ensuring that these provisions are not used except in, I mean, there are ways of doing it.
Rarest of rare.
I mean, it's like we used to have in context of arrest. At some stage, when the arrest power is being thoroughly misused in some legislations, they said that the power of arrest will be exercised this was the internal administrative process and sometimes statutory, only with the authorization of the director or the deputy director. Then they started again relaxing it and saying they delegated the authority. Because then it's become very easy for a junior officer to keep arresting and taking action. If you want to have these kind of extraordinary and draconian powers, they should be exercised only with the authority of somebody very, very high, like a director who has to give proper reasons why this power is being exercised. And the challenge we face is that there's a concept of reason to believe in many of these legislations, but all of these, you do not, courts say that it should be made available, nobody makes it available. And therefore you don't have the ability to challenge these things. So a lot of it is, as jurisprudence stands, it's all there. It's implementation which creates the challenges.
Thank you, sir. Thank you. Really appreciate it.
Thank you very much. Yes, Saurabh, you were saying.
Can't hear you. You're on mute.
Yes, yes. No, I was not able to unmute myself. Yes. So what I'd like to request Mr. Shroff and Mr. Desai, if we can get your suggestions in the bullet points in terms of what changes can be further incorporated, as the chamber will be happy to collate and put it before the concerned ministry. So that's the humble request.
Neither does Amit have the time, nor do I have the time. Whatever
just a bullet point, or
convert it.
we will prepare and we will send it to you, sir.
You send us, then we'll we'll mark it up.
Perfect. That would be great. So with this, I would like to invite Mr. Ajit Mangrulkar, Director General of IMC Chamber of Commerce and Industry, to propose a vote of thanks.
Thank you, Mr. Shah, and good evening, ladies and gentlemen. On behalf of IMC Chamber of Commerce and Industry, it is my proud privilege to propose the vote of thanks at what has been an absolute fantastic session. I'm pretty certain that if it wasn't for time, we could have gone on and listened to the legal luminaries that are in front of us, and probably we would have had our nice bunch of notes for IMC to be preparing a nice document. But thank you very much. I'm grateful to Mr. MP Shah, Regional Director, West, Ministry of Corporate Affairs, Mumbai, for sparing his valuable time and sharing his rich experience and thoughts on the subject. I really would like to thank our fantastic panel speakers, Mr. Manoranjan Das, Registrar of Companies, Mumbai, Mr. Shardul Shroff, Chairman, Shardul Amarchanddas, Mangaldas and Company, Mr. Amit Desai, Senior Advocate, for taking out their time. I know all of you all are really very busy, but taking out a time from your busy schedule and for sharing your wisdom and insight on a very significant topic. I would also like to thank Mr. Suresh Kotak, Mr. Sailesh Haribhakti, and Mr. Narayan Shankar for their active participation in today's session. On behalf of IMC, I would like to thank Bharat Diamond Bose for sponsoring this event. I would also like to thank Ms. Radhika Dudat Pereira and Mr. Saurabh Shah for fantastically moderating today's engaging session. I know you've been really toying around with all the experts on the panel, but it's been a great session. I would like to thank our IMC team led by Sia Wagle and everyone to put this whole discussion together. And we look forward to many more interactive sessions to discuss the finer nuances of amendments to existing laws and enactments of new laws. Having said that, on Saturday, 21st at 4 p.m., our Ladies Wing Legal Committee is having another session, and it's an interesting session which has got Honorable Justice G.S. Sistani on the panel. And this is about your legacy handbook. I think there'll be an interesting discussion, and I request all of you all to look up our IMC events and be part of this discussion also. So thank you very much for sparing your valuable time, and for all you wonderful panelists for having a brilliant discussion. Thank you very much.
Thank you.
Thank you.
Yeah, y'all can mute yourselves and say what. Yeah.
We leave?
Yes, sir. Sir. Thank you, sir.
Thank you very much. Thank you.
Yeah.
Thank you. Thank you.
Thank you, sir.
Thank you, Ms. Selby. Thank you very much
Thank you
for all the support. Thank you.